Right. So as we talked about earlier, Rachel, the Republican Party in Dallas County decided they did not want to have countywide elections. They wanted to make people go to their assigned polling place locally. And if the Republicans say you can't have countywide, then the Democrats can't have countywide. So Democratic voters showed up thinking they were going to be able to vote at the places around the county they had voted, and they were turned away. And there was a big push to try to extend voting in Dallas County as a result of that, to give those people an opportunity to vote after all. A Dallas judge ordered the polls open until 9. Well, Attorney General Ken Paxton asked the Texas Supreme Court within the last couple of hours to overturn the Dallas judge's ruling.
350 people were turned away from the polls, not because they showed up late, not because they were ineligible, not because the system failed by accident. They were turned away because the system worked exactly as designed. What you are about to hear is not a theory. It is a documented, legal, procedural operation carried out by the highest offices of the state of Texas to restrict who gets to vote and to ensure that when chaos erupts, it erupts precisely in the places where it will damage Democratic turnout the most. Every step of what follows was a choice. Every legal filing, every administrative veto, every emergency petition submitted after 7 o'clock on a primary night was made by someone with a name, a title, and a calculable political interest in the outcome. This is the story of Dallas County, the Democratic primary between James Talarico and Jasmine Crockett, and the legal machinery that Texas Attorney General Ken Paxton activated on primary night to stop a judge's lawful order and freeze the ballots of citizens who had done absolutely nothing wrong.
Well, I mean, at one level, it's pretty insane to have a candidate who's on the ballot being the litigant who gets to decide. I mean, he's the state's attorney general, but getting to weigh in. I don't know if there's a particular valence to those votes at that hour for him. I think it's mostly about the Democratic primary. It also feels a little bit to me like if the calculation of the Republican establishment is that Crockett's an easier candidate to beat, that this goes against that, but like he's just doing it for love of the game. Yeah. You know what I mean? Like he's just super committed to making it hard for people to vote as just a deeply held view. And you know what I mean? Like
and making it hard to vote in Dallas.
Yes,
so
right.
In a big purple/red state, you take the cities that are very blue and you say those places have terrible voting. Look what a mess.
The lie at the center of this story is specific, repeated, and structurally necessary to everything that followed. The precise narrative, delivered by Donald Trump, by the Republican Party apparatus in Texas, and by the political ecosystem that surrounds them, is that you cannot trust the votes from Democratic strongholds. The claim is not abstract. It is targeted. You cannot trust the votes from cities. You cannot trust the votes from places with large populations of people of color. Election officials in those places are either incompetent or corrupt, and the results they produce are inherently suspect. This lie is the operating premise. It is the justification that must already exist in the public mind before the operation begins, because the operation itself requires a preceded narrative of corruption to draw on the moment confusion appears. And the confusion in Dallas County on primary night was not an accident waiting to happen. It was a condition deliberately manufactured by the local Republican Party. The lie preceded the chaos because the lie is what makes the chaos usable. Without the prior installation of distrust, manufactured disorder has no political value. With it, every moment of voter confusion becomes evidence of the corruption that was never actually there.
Specific about it, right? The narrative from Trump and the Republicans, from Trump in particular, from the Trump movement, is you can't trust votes that come from Democratic strongholds.
Right. Yes.
So you can't trust votes from cities. You can't trust votes from places that have lots of people of color. So they're trying to make, it makes sense to fit the political narrative to try to make the Dallas votes, and I'm sure they hope the Houston votes or any other votes that fit that narrative, seem as unknowable as possible, so as to create a pretext for being able to exclude them from the totals from that state.
And
it is worth noting this is the same political apparatus that was sued by Dominion Voting Systems and forced to pay nearly $800 million for broadcasting those same fraudulent election claims to its audience. The lie is consistent. The lie is structural. It has a price tag. And in Texas on primary night, the lie had a legal engine behind it.
Go upstream causally, the whole reason we're here, right, is because the County GOP refused to co-sign a memorandum of understanding to allow countywide voting They had a demand for paper ballots, which again, like, has nothing to do with anything. There's no reason to think that they're better, right? That's a Donald Trump obsession. That's an election denier obsession. Like the whole causal chain that created the confusion that led to the necessity of opening the election earlier was the local Republican county party doing this.
And to that point, because it's really important to make that logistical point about what went wrong here. So now we've got this order from the Supreme Court of Texas that says, what's the remedy here? Well, we've paused the extension of the voting hours.
Here is what the documentary record proves, precisely and without embellishment. The Dallas County Republican Party refused to co-sign a memorandum of understanding that would have allowed countywide voting. This is not a procedural footnote. Under Texas election rules, if the Republican Party refuses to participate in a joint countywide voting arrangement, the Democratic Party cannot implement one either. By exercising that administrative veto, the local Republican Party forced Democratic voters who had previously cast their ballots at locations scattered across the county, to suddenly find their single assigned polling place. Many of them did not know where that place was. The websites designed to provide that information crashed under the demand. The search tools voters were directed to use became inaccessible at the exact moment they were most needed. Citizens who had voted in previous elections without incident showed up at familiar locations and were turned away without a path forward. By 5:30 in the evening, at a single polling location, 388 people had voted. An estimated 350 had been turned away. Voters stood in line with tears on their faces, not knowing where to go, not understanding what had happened to a process they had trusted for years. The Republicans also demanded paper ballots, a known fixation of election denial activists, without any evidence that paper ballots would produce a more accurate or reliable outcome. Every element of the administrative structure that created this confusion was a deliberate choice made by the local Republican Party before a single vote was cast. The chaos did not emerge from the complexity of running an election. It was engineered.
And kept. Now, the big question is, will they be counted? And I can tell you from talking to voters who had gone to multiple polling places, trying to find the right polling place, one woman who was in tears earlier today, and a woman that I literally interviewed moments before the polls closed because this Texas Supreme Court ruling came down. They were all worried about their vote counting, and they were all talking about how this was, quote, voter suppression, because they were really trying to vote and they just couldn't vote. Like I said before, I'm a data girl, Rachel. And just to give you a sense, as I mentioned earlier, here at about 5:30 p.m. Central Time, 388 people had voted at this polling place. And according to the election judge, again, of the Democratic Party, about 350 had been turned away.
A Dallas County judge assessed the situation and responded with the appropriate legal tool. The judge issued an order extending voting hours until 9 o'clock at night, granting those displaced voters additional time to locate their assigned polling places and participate in the election they had every legal right to participate in. That order was a form of injunctive relief, an emergency equitable remedy issued by a judge who recognized that a severe logistical failure had denied citizens access to the ballot through no fault of their own. And then Ken Paxton moved. The power analysis here must be understood with absolute clarity, because what happened next was not routine legal activity. It was a targeted intervention by a sitting candidate who used the official machinery of his office to interfere in the primary election of the opposing party. Ken Paxton is the Attorney General of the state of Texas. He is also a candidate in the Republican Senate primary, actively running against incumbent Senator John Cornyn for a seat in the United States Senate. On primary night, with Democratic voters still attempting to locate their polling places, Paxton filed an emergency petition with the Texas Supreme Court asking it to overturn the Dallas judge's ruling and halt the extended voting hours entirely. He used taxpayer resources. He used his official authority as the state's chief law enforcement officer. He deployed the legal weight of the Attorney General's office, not to protect Texas voters, but to ensure that fewer of them cast ballots in a primary he had no legitimate institutional interest in controlling. He has no stake in the Democratic primary. The outcome of the Talarico-Crockett race carries no consequence for his Senate campaign against Cornyn. There is no reading of his official duties, no interpretation of his statutory responsibilities, no account of his role as Texas Attorney General that required him to be involved in this race on this night. and yet he was. The only logical explanation for this extraordinary intervention is political. He wanted fewer Democratic votes counted in a state where the November general election will be decided at the margins. And the Texas Supreme Court gave him exactly what he asked for. The credibility of the man who activated this machinery deserves examination because the fitness of the official is inseparable from the legitimacy of the act. Ken Paxton was impeached in 2023 by his own party, Texas Republicans in the state legislature, on formal allegations that he abused his office to conceal an extramarital affair. He has been under federal bribery investigation. The United States Department of Justice declined to prosecute those bribery allegations only in early 2025, leaving a thoroughly investigated official still in command of the state's legal apparatus. He has also been under a long-running state securities fraud investigation and was required to pay a substantial settlement to the individuals he allegedly defrauded. In the current Republican Senate primary, Senator Cornyn's campaign, funded in part by the Republican Senatorial Committee, has run television advertisements calling Paxton a wife cheater and fraud. Those advertisements note that Paxton's wife filed for divorce on explicitly biblical grounds and that Paxton maintained a relationship with the married mother of 7. Cornyn has publicly stated that Judgment Day is coming for Ken Paxton. This is the official who directed the emergency legal intervention that froze the ballots of Dallas County Democratic voters on primary night. His documented history of using the justice system to protect himself and damage his adversaries is the essential context for understanding what happened in Dallas County. His actions there are not an anomaly. They confirm a pattern. The defense argument offered for Paxton's intervention and the Supreme Court's response rests on a single pillar: the strict, literal text of Texas Election Code Section 41-032. This statute, dating to 1985, specifies that voting in Texas shall occur between 7 in the morning and 7 at night. The defense asserts that the Texas Supreme Court was fulfilling its constitutional obligation by enforcing an unambiguous 40-year-old law, that the lower court's extension order exceeded judicial authority, and that the stay issued by the Supreme Court was a lawful, necessary correction to a judge who had overstepped her mandate. They frame this as the faithful application of a clear statutory text. They argue this is not voter suppression. It is the rule of law, applied consistently and without political preference. That argument collapses under the weight of two documented facts. First, in May of 2024, an extension of voting hours was explicitly granted in Dallas County due to severe power outages at approximately 100 polling locations. The legal precedent for extending hours in response to administrative failures clearly exists. The 1985 statute has not been treated as an impenetrable wall when logistical disasters prevent citizens from exercising their constitutional rights. The defense cannot claim absolute fidelity to a law that the same legal system has previously waived under directly comparable circumstances. Second, the Supreme Court's order is operationally impossible to execute. The order required that any votes cast by individuals not physically standing in line at 7 o'clock be segregated from the valid ballot pool. But election officials had received judicial clearance from the lower court to extend hours before the 7 o'clock deadline arrived. They had no legal or logistical reason to document who was in line at that precise moment because the extension was already in legal effect. No chalk line was drawn. No official photographed or recorded the composition of the queue at 7 o'clock. The Supreme Court's instruction therefore demands a retroactive accounting that cannot physically be produced. The law is not being faithfully applied. It is being weaponized. A 40-year-old statute is being deployed in demonstrable bad faith to manufacture a legal trap that casts a permanent shadow of illegitimacy over an entire batch of ballots. Ballots cast by citizens who waited patiently for a court-authorized extension of time. To understand the full mechanics of what occurred, two legal concepts require plain language explanation. When Attorney General Paxton asked the Texas Supreme Court to intervene, he filed what is known as a petition for a writ of mandamus. A writ of mandamus is an extraordinary legal order from a higher court commanding a lower government official or a lower court to fulfill their duties according to the law as the higher court interprets it. It is not a routine appeal. It is an emergency power reserved for situations where ordinary legal remedies are considered insufficient. Paxton asked the state's highest court to use that emergency power to force Dallas County to immediately shut down the extended voting window. The Texas Supreme Court did not issue a final ruling on the full merits of the case. Instead, it issued a stay. A stay is a legal pause. It freezes the current state of affairs while the underlying legal arguments remain pending before the court. By staying the lower court's extension order, the Supreme Court effectively canceled the extended hours before the case was ever fully argued. Combined with the impossible segregation mandate, order the workers to separate votes by a timeline they never recorded, this legal sequence accomplished a specific outcome. It cast doubt on every vote cast after 7 o'clock, made those votes impossible to definitively validate, and left their legal status in permanent suspension. That is not a side effect of a legitimate legal proceeding. That is the designed result of a legal maneuver executed under time pressure, with full knowledge of what it would produce on the ground. The authority underpinning this analysis draws from the reporting of Eleanor Klibanoff at the Texas Tribune, the veteran political observation of Evan Smith at Austin PBS, with 30 years of direct experience in Texas politics, the analytical framework of pollster Matt Towery, the on-the-ground reporting of Rosa Flores, who interviewed the election judges, and the voters who were turned away at Dallas County polling locations, the legal parsing of Chris Hayes regarding the Supreme Court orders, the reporting of Simone Sanders Townsend on the rules governing primary administration, and the direct public statements of the candidates themselves, including Representative Jasmine Crockett and Senator John Cornyn. Every claim made in this documentary is tethered to documented, publicly available sources. No speculation has been employed at any stage of this analysis. The institutions designed to protect voters have failed at every level. The local Dallas County Republican Party used its administrative authority to intentionally block the standard joint primary procedures, manufacturing the logistical confusion that displaced hundreds of legitimate voters. The Texas Supreme Court, operating under documented influence from political dark money and shaped by years of partisan judicial elections, issued a stay that imposed an impossible retroactive requirement on local election workers and froze ballots that may never be counted. The Department of Justice declined to prosecute Ken Paxton for bribery in 2025, leaving a thoroughly compromised official in unchallenged control of the state's enforcement apparatus. The oversight mechanisms that are supposed to prevent exactly this kind of politically motivated interference, federal oversight, judicial independence, prosecutorial accountability, have each failed at precisely the moment they were needed. There is no functioning institutional check on what occurred in Dallas County. The mechanisms of accountability are either paralyzed by political alignment or actively participating in the outcome. The immediate electoral consequences are as follows. In the Democratic primary, State Senator James Talarico has secured the nomination over Congresswoman Jasmine Crockett. Crockett has lost her Senate bid and will be out of Congress at the conclusion of this term. The votes cast in Dallas County between 7 and 9 o'clock remain in legal suspension, with no guarantee they will ever be formally counted. On the Republican side, Senator John Cornyn failed to reach 50% of the vote and is now forced into a runoff against Ken Paxton, officially scheduled for May 26th. Both Republican candidates will continue spending millions in aggressive attacks on each other throughout that contest. The legal consequences extend to the ballots themselves. Those segregated votes exist in a state of permanent legal uncertainty, subject to future court proceedings with no assured resolution. The voters who cast them in good faith, who followed the legal instruction of a sitting judge, have been retroactively penalized for trusting the judicial system that was simultaneously being used against them. The systemic consequences are the most significant and the most durable. The legal and administrative framework deployed in Dallas County on primary night is now a validated template with a documented chain of custody, from local party administrative veto to manufactured confusion to emergency judicial intervention to Supreme Court stay, that any state official in any other county can now replicate with the knowledge that it has already survived legal scrutiny at the highest level. The Texas Supreme Court has officially sanctioned the use of an emergency stay to override a local judge who attempted to remedy a manufactured administrative failure. The machinery for this kind of targeted, localized voter suppression is fully operational and legally defensible under the framework now established by the state's highest court. It has been tested under live conditions, deployed against a real election, and upheld by the state's highest court. As November approaches, every voter in every major urban county in Texas should understand clearly and without ambiguity that the system that failed in Dallas County has not been corrected or investigated. It has been endorsed. Before we close, one quick clarification. Everything presented in this documentary is drawn entirely from publicly available reporting, official court records, documented statements, and named sources, all referenced throughout this analysis. This is not a call to action of any kind. It is an evidence-based examination of public events as recorded in the documentary record. Reasonable people examining the same facts may reach different legal or political conclusions, and that disagreement is itself a legitimate and necessary part of democratic discourse. What is not open to reasonable dispute are the events themselves, the administrative decisions made before primary night, the emergency petition filed by the Attorney General, and the stay issued by the Texas Supreme Court. Those are facts in the public record. If this kind of rigorous, source-grounded political analysis serves you, please consider subscribing and adding your perspective in the comments below. Thoughtful, well-informed civic engagement with these questions is precisely how democratic accountability is built and sustained over time.